As a franchisor, sometimes you need to deal with a termination of a franchise. Sometimes a termination can be friendly. For example, if both you and the franchisee decide that the franchisee should sell, then you may be able to work together, sell the franchise, and move on. But sometimes the termination can be unfriendly. For example, if the franchisee is not following your system and hurting the reputation of your business and the reputation of other franchisees. In that case, you may be required to terminate the franchisee. But you need to be extremely careful. First, you need to look at the provisions in your franchise agreement for termination. Generally, you're required to give the franchisee notice, and in some cases, you may be required to give the franchisee a certain amount of time to cure the default before you terminate. For example, 10 days to pay any unpaid fees that have not been paid, or 30 days to come back into compliance with the system. But even after you look at your franchise agreement, you cannot rely totally on the agreement. You also need to consider whether a state law might protect the franchisee. About half of the states in this country have laws protecting franchisees from unfair terminations. So even though you may have the right to terminate a franchisee under your franchise agreement, that state law may give the franchisee other rights and may impose other obligations on you. And if the obligations of the state law are greater on you than the obligations under your franchise agreement, you must follow the state law. In that case, if you do not follow the law, the franchisee, even though you may be very justified in terminating them, may have the right to sue you for damages caused by your termination, which can be very substantial.